Hi, my name is Hanifaikal bin Osman, and I will be presenting about the federalism in Malaysia. Federalism in Malaysia is about balancing power between the federal and state government. This system helps maintain national unity while also respecting the rights and diversity of each states, which is especially about multiracial or multi-religious country such as Malaysia. In this system, the federal constitution guides how the power is shared under the ninth schedule. Power are divided into three main lists, which is the first one is the federal list, the second one is the state list, and finally the last one is concurrent list. The federal list will cover about the matters like a defense, foreign affair, or even education. The second one is a state list, which will cover about land matters, or even local government. And lastly, the concurrent list will cover about both of level of government will cover about public health, social welfare, or even planning. Each state in Malaysia has its own state constitution, legislative assembly, and executive council, commonly known as EXCO. The head of the state is either Sultan or a governor, and at the national level, we have the Yang di-Pertuan Agong as the federal head of state. This federal structure helps ensure that Malaysia will run smoothly with clear responsibilities at both state and at federal level. Thank you. Now we will be talking about the written law, which is a law that are formally written and documented. These are the main sources that guide our legal system. Firstly, we have the federal and state constitution. The federal constitution is a supreme law of the country, and each state also have its own constitution. Secondly, these are acts and legislation which are law made by parliament at the federal level and or by state legislative assemblies. Lastly, we have subsidiary legislation. These are law made by the authorities or bodies under power given and acts, such as regulation or bylaws. Together, this written law provides the legal foundation and for how Malaysia is governed.
So, my name is Muhammad Jailhan Bidikni, and I will be explaining about the constitutional supremacy. Now, constitutional supremacy in Malaysia, particularly within the framework of a constitutional monarchy. In Malaysia, we practice a constitutional monarchy, which means that the Yang di-Pertuan Agong, or the king, serves as the head of the state, but his powers are limited and clearly defined by the federal constitution. The real executive power lies with the elected representative, especially the prime minister and the cabinet. They make the decision and govern the country, while the king acts based on the advice, except in the few specific situations stated in the constitution. Okay, so how was the king elected? Every 5 years, the Council of Rulers, which include the 9 Malay rulers and the 4 Yang di-Pertuan Negeri, gather to elect a new Yang di-Pertuan Agong. This unique system allows the position of the head of the state to rotate among the rulers, making Malaysia one of the few countries in the world to have an elected monarchy. Yang di-Pertuan Agong acts on the advice of the cabinet members or a minister working under general authority of the cabinet, unless this constitution says otherwise. However, he is entitled, upon request, to any information related to the federation governs that the cabinet has access to. Malaysia unique and symbolic constitutional monarchy is based on history, yet stick to the principle of democracy. In addition to serving as a protector of the constitution, Yang di-Pertuan Agong is an important figure in political transition and an image of Malays and Islamic identity. However, the elected government and the parliament holds the actual political power. Okay. Next one is the state autonomy in Sarawak and Sabah. State autonomy refers to the special rights and powers given to these two states by the Federal Constitution of Malaysia, especially the Malaysia Agreement 1963. These autonomies set them aside from the Peninsular Malaysia, others 11 states. The Malaysian Agreement 1963. In 1963, Sabah and Sarawak become part of Malaysia with some protection to protect their interests and identity, to rights related to religion, language, land, and custom and law to establish. The first one is a religion. Islam is an official religion of the Federation, while Sabah and Sarawak were granted the right to practice any faith. The second one is a language. According to MA 63, Malaysian Agreement 1963, English is allowed in Sabah and Sarawak for the official state government and legal purposes, even though Bahasa Malaysia is the country official language. The third one is a land. Forest resource and the land problem are solely under the authority of both states, Sabah and Sarawak, while the Federation government cannot impose decisions regarding lands use without the state consents. And the last one is custom and law. Indigenous people laws and customs, such as those of the Bidayu, Iban, Kadazan Dusun, are protected. Native courts are in place to deal with issues such as customary land right and traditional marriage. So, Sabah and Sarawak states' autonomy is an example of Malaysia uneven federalism, which treats states differently. Their culture identity, economic interests, and the 1963 political agreement to all designed to be protected by this special right.
Next is power division, which is federal versus state. Malaysia has a federal system of government, which means that the federal central government and the state governments both share the same governance authority. The Federal Constitution of Malaysia mainly describes this distribution of powers, especially in the ninth schedule, which divides powers into three primary lists. This list includes the federal list, the state list, and the concurrent list. Next, there are a few similarities between federal and state. First, both have legislative powers. Though on distinct topics, the federal and state governments are both able to enact laws. Secondly, both have separate legislative bodies. Every governmental level has a separate legislative body, which is the Dewan Rakyat and the Dewan Negara. Both of these make up parliament at the federal level. Lastly, both handle governance and public services. The management of public administration and services falls under the purview of both governments. Now, for the differences between federal and state, firstly is jurisdiction and powers. Defense, foreign policy, internal security, finance, and citizenship are only a few of the domestic and global issues that are managed by the federal government. Local issues like forestry, Islamic affairs, land management, and local government services are handled by the state government. Secondly is legislative bodies. The parliament, which is made up of the lower house, Dewan Rakyat, and the upper house, Dewan Negara, is the federal legislative body. Only within the state borders can legislation be passed by the state legislative assembly, DUN, the legislative arm of the state government. And lastly is financial power and revenue. The federal government controls national taxation and revenue. including income tax, custom duties, and national budget. State governments have limited financial powers and mainly rely on land revenue, forestry, and federal grants. Now, how does this affect the construction industry? Firstly, laws and regulations. In construction, federal laws set the framework while state laws and policies implement or adapt it based on local needs. Secondly is permit. There are few permits that the state has allowed to be used, which is land conversion, planning permission, building plan approval, and finally earthwork approval. Lastly is labor and employment laws. Labor laws in Malaysia fall under federal jurisdiction, including Employment Act 1955, Minimum Wages Order, and Occupational Safety and Health Act 1994, which is under OSHA. These laws apply uniformly across all states to ensure consistent worker rights and safety standards. Next, I will be giving you an example case. This case is between Aliran Perak Sdn Bhd versus the Menteri Sumber Asli, Alam Sekitar dan Perubahan Iklim (NORS) 2023. A government rule was introduced that forbade any development within a specific radius of forest reserve. The rule did not provide compensation to affected contractors or landowners. Now, Aliran Perak Sdn Bhd, a construction company, challenged the rule under the amended Environmental Quality Act. The company had already invested significantly in development projects and had obtained prior approval. The company argued that the rule violated Article 13 of the Federal Constitution, which protects the right to property and states that no one should be deprived of property without adequate compensation.
Now, I will be talking about the tort law. What is a tort law? Tort law is a part of a civil law. That means it deals with where one person cause harm to another person, not through crime, but through carelessness or even a wrongful action. The main purpose of tort law is to make sure that injured person get compensation for things like a personal loss, physical injury, or property damage. In the construction field, the tort law is very important because the industry is risky and involves many different people, like as engineer, contractor, or a public. If someone make a mistake or ignore safety, and someone else get hurt and suffer loss, tort law can be used to make them responsible. This help keep construction work safe, fair, and even professional. What are the examples of a tort law? The first one is negligence. What is negligence? Negligence simply means failing to be careful when you're supposed to be. In law, when someone doesn't take a reasonable care of the action or lack of action, they will cause a harm to another person. In construction, this can happen when a professional like contractor or engineer doesn't follow the safety standard or use poor material. Negligence become a legal issue when this carelessness leads to injury, damage, or loss. Negligence can be divided into four categories, which is the duty of care, breach of duty, causation, injury, or damage. In construction, a duty of care means that a professional like contractor, engineer, or architect, or even a site supervisor have a legal responsibility to avoid causing harm. These duties are not only applied to worker or client, but also to the public and anyone who might be affected by the works. For example, an engineer must ensure the building design is safe, while a contractor must follow plans and use the correct material. A breach of duty happens when someone fails to meet the expected level of care. In other words, they do not act the way a careful and responsible person would in the same situation. For instance, if a supervisor ignores a safety rule or fails to fix a dangerous scaffolding and someone gets hurt, that will be considered a breach of duty. Damage or loss. Finally, there must be actual harm or damage. This can be a physical injury, a property damage, or financial loss. For example, if someone get injured because of poor supervision or a building cracks or bad material, the damage is real and measurable. Without proof and actual harm, a negligence claim cannot succeed. In summary, for negligence to exist, all four elements must be proven: duty of care, breach of that duty, causation, and actual damage or loss. This principle help keep the construction industry safe, responsible, and legally accountable. Thank you. Causation links the breach harm that happened. To prove this, we ask a simple question: but for the person action, would the harm happen? If the answer is no, then the causation is established. Also, the damage must be something that could be reasonably expected. It cannot be too far, fetched, or even unrelated to the action. The case law in Malaysia regarding the negligence. The first one is the duty of care case by Majlis Perbandaran Ampang Jaya versus Stephen Paul Cheng Leong. The first element of negligence is a duty of care. In construction, this means professionals like contractor, engineer, and local authorities have a legally responsibility to make sure the action do not cause harm. A famous case that shows this is a landslide at Bukit Atabangsa. The court found that the municipal council knew about the danger but allowed unsafe development. Because they didn't act, people died and property was destroyed. This case proved that duty of care applies not just to workers or clients but to the public too. Now we move on to the breach of duty, the case by Government of Malaysia versus Lai Kitty. The second element is a breach of duty. This happens when someone fails to do their job with a proper care. For example, in the Lai Kitty case, the government did maintain drainage system which caused a flooding and damage to the property. The court said this was a breach of duty because the government didn't act and like a responsibility authority should have. This case showed that negligence can happen through inaction when someone knows there's a risk but doesn't do anything about it. Moving on to the next case, which is Yap Sing Hock versus Oswald Victor Rodriguez. Finally, to prove negligence, the person must have suffered a real damage. In the Yap Sing Hock case, a contractor work caused a crack and instability in the nearby building. The court said this was real, measurable damage, not just a guess or a worry. The plaintiff was awarded compensation. This showed that in court you need a strong evidence like an expert report to prove that actual harm was done.
Okay, so my name is Muhammad Shalhan bin Ibni, and I will be explaining about the law of trespass. The trespass is an entry of one person into a property of another person without their consent or approval. It occurs when there is a direct interference with first, person, second, goods, and land. So the first one is trespass to person. It involves a direct contact between two persons or more. It can be intentional or unintentional. There are three categories to trespass to person, which is first, assault, second, battery, and third is false imprisonment. Next one is goods. Trespass to goods involve when the person intentionally taking or interference with another person movable property or belongings without their consent. The last one is land. Trespass to land is happening when the person decide to enter another person's land without authority and permissions. Walking into lands without permission or refusing to leave when permission has been withdrawn, or throwing objects into the land are all examples of trespass to land. It is based of the real case by Baisley versus Clarkson in 1681. In Malaysia tort of law, the trespass to land are the most common case in the construction and the property development. Trespass is common in construction project, usually when site boundaries is unclear to the people surrounding or construction work is one in the neighboring plots. For example, during the construction of male dormitory in UiTM Sarawak, Block 6, some students use the walkway which is inside the site boundary as a shortcut, despite the clear sign of no trespassing. Next, I will be explaining about the case law analysis in Malaysia. The case is Fun Fat versus Datuk Bandar Kuala Lumpur 2023. Fun Fat accused DBKL of trespass by using and occupying his land without permission between February 13, 2008 to October 8, 2017. However, on October 9, 2017, the state forcibly purchased the land in question to build a highway. Fun Fat did not pursue land reference procedure under the Land Acquisition Act 1960 LLA, despite accepting more than Rm 10 million ringgit in compensation from the land administrator. On October 6, 2020, he then filed the trespass complaint in the High Court. The plaintiff must have the legal claim in or ownership of the land at the time of the trespass lawsuit by October 6, 2020. Fun Fat has lost ownership of the land because on October 9, 2017, the state purchased the land, and on the October 3, 2020, Form K was registered, formally transferring the land of the state in the accordance of the Section 23 of the Land Acquisition Act 1960 LLA. The plaintiff has no right to file the trespass lawsuit since he has lost ownership and failed to act in line with the proper legal framework LLA. By properly reject the case, the courts maintain the rules that you cannot file the trespass lawsuit on property you no longer own. This case has its own legal consequences, which is the first one is a liability. Trespassing is a strict liability tort, meaning that if someone enter or disturb with the property without consent, they are normally held guilty. But the defendant, DBKL, in this case was not held liable because the land was already purchased and vested in the government September 20 using Form K under the Land Acquisition Act 1960. So, by the time the trespass claim was submitted in October 2020, therefore, the plaintiff ownership and legal interest in the land were cancelled. He was then unable to prove that he has been trespassed against. The second one is defense. The lack of focus standing was DBKL primary defense, which was court upheld. To file a lawsuit, the plaintiff must have had an actual right to the ownership at that time of the trespass. The plaintiff was unable to prove any legal harm under trespass as the land has been purchased by the government and he no longer had any ownership or ownership claim. The third one is remedies. No remedies were granted to the plaintiff because the court decided in favor of the defendant, DBKL.
Thirdly, engage with nearby property owners, such as reduce private nuisance claims such as noise, vibration, and dust. Reference legal case such as Go Chok Tong versus Jayapuri Chinese Garden. Actions to take is to notify neighbors before work starts, create channels for feedback, and use mitigation tools.
Now, next is nuisance. The definition of nuisance is when someone's use of the land unfairly impedes another person's use or enjoyment of their own land. It is referred to be a nuisance under Malaysian tort law. Nuisance in Malaysia generally is divided into two main types, which are private nuisance and public nuisance. Now, I will be giving you a few examples of nuisance. Firstly, when a developer creates excessive dust or noise that disturbs the neighbors. Secondly, your property floods as a result of your neighbor's inadequate drainage system. Thirdly, a nearby residence is disturbed when the manufacturing releases smoke or unpleasant odors. Fourthly, blocking a public road or walkway with construction materials causing danger or inconvenience to pedestrians and traffic. Fifthly, excessive noise and dust from construction activities affecting an entire neighborhood over a long period. And lastly, uncontrolled release of construction waste or runoff into public drains or roads, creating health or environmental hazards. Now, the application of nuisance in construction. Case example, Tan Boon Hock versus Teh Eng Hong Realty Sdn Bhd. Developer is liable for soil subsidence and cracks from piling. Even legal construction can become unlawful if it harms others. Contractors must follow safety and environmental rules, plan carefully, and engage with affected landowners. Nuisance law ensures responsible development and protects public and private rights. Now, the application of nuisance in construction. Case example, Tan Boon Hock versus Teh Eng Hong Realty Sdn Bhd. Developer is liable for soil subsidence and cracks from piling. Even legal construction can become unlawful if it harms others. Contractors must follow safety and environmental rules, plan carefully, and engage with affected landowners. Nuisance law ensures responsible development and protects public and private rights. Now, one of the most famous case law is between Abdul Ghani bin Ali versus Cawat 1000 Sdn Bhd 1994 to MLJ 159. In this case, Abdul Ghani, the plaintiff, owned land next to the construction site. Cawat 1000 Sdn Bhd, the defendant, was conducting land clearance and building works. The defendant activities included excavation and soil removal. These actions caused soil erosion and water discharge onto the plaintiff's farm. As a result, the plaintiff's land suffered flooding and property damage. Next, the legal issue is whether the defendant was responsible for the harm done to the nearby land and whether the construction and land clearing operations constituted a nuisance. So, the conclusion of this case is the court ruled that the defendant's actions amounted to a private nuisance. Judgment was in favor of the plaintiff. The defendant failed to take proper steps to prevent soil and water intrusions onto the plaintiff's land. The interference was deemed significant, avoidable, and unreasonable. The analysis for this case is the case highlights liability for construction nuisance due to poor site management. Developers must control erosion and water flow to avoid harming neighboring land. The court reaffirmed that landowners cannot use their property in a way that endangers neighbors' property. Even legal construction work can be deemed a nuisance if it causes physical damage or interferes with property enjoyment. Emphasizes the need for effective environmental control measures, especially near other properties. Failure to do so may lead to legal action and compensation claims.
Next is why understanding federal and state law matters in construction in Malaysia. Malaysia's construction industry is governed by federal, state, and local laws. Key federal acts like the OSHA 1994 and the Uniform Building Bylaws set national safety and building standards. However, federal laws must be adopted and gazetted by each state before enforcement, meaning application can vary across regions. Local authorities then handle enforcement, including permits, inspection, and zoning. 1, 2, 3. Next is tips for contractors to stay compliant across states. Firstly is to maintain proper licensing. These
This is to obtain correct licenses in every operating jurisdiction. It is also to differentiate between general and specialist contractor licenses. Failure to comply may lead to heavy fines and loss of business opportunities. 223. Next is to classify workers correctly. It is to differentiate between employees and independent contractors. Misclassification can lead to audits and financial penalties. 223. Next is use clear state-specific contracts. Project scope, deadlines, and payment terms. It also reduces legal risk and confusion. Next is stay informed and proactive. Join industry association, subscribe to legal and regulatory updates, and lastly, seek ongoing legal counsel. 223. In conclusion, construction projects involve many risks from financial issues to safety concerns. To manage this, a proactive and structured risk mitigation strategy is essential. Start by identifying risks early through assessments and past project data. Then develop a clear risk management plan with assigned responsibilities. Enforce strict safety and compliance standards, conduct regular audits, and ensure training is ongoing. Strengthen contract terms, screen vendors carefully, and maintain flexibility in your budget and schedule to handle unexpected challenges. And lastly, clear communication and regular monitoring help teams stay informed and respond quickly. These best practices support safer, more efficient, and legally compliant construction projects.